So we're just giving everyone another minute or so. We're gonna get rolling, probably even less than that. Um, and then we'll get the show on the road. Yeah, and Mike, I have the exhibits ready to go, so they should be easy to pull. Um, all right, so I guess let's roll. So first of all, good afternoon, everyone. Welcome to I guess what it's season 6, episode 5 of the Blueprints. How to execute an effective deposition, where I am joined by my dear friend Michael Levine, who I consider to be an OG of the Blueprints. I told him just a few moments ago I wasn't sure if I was going to be able to get him back, but we got him back. And so before we get going, I'm going to try and address sort of what I try and do every episode, which is address kind of the purpose and the intention behind the episode. And this one is special for two reasons. One is uh, this is how this blueprint started, right? Blueprint started only with us talking about depositions. And what I mean by that is, when I came over from criminal to civil, and when I was, moved from being a prosecutor over, I quickly realized that we took depositions in criminal, but it was not the main thing. The main thing was trial, and I quickly realized in civil practice that, in my opinion, too many people treated a deposition just like as another. We're just going to have a conversation, and I felt like if more people treated depositions like they prepared for trial in civil practice, we would have better lawyers, and we'd probably be able to resolve cases more effectively. So thankfully, I met Mike, and Mike was like one of my best friends, quick best friends in civil. And I quickly learned that he was as much of a dork as I was. And so we started talking about depositions just constantly. And I'd say, hey, can you read the transcript? Or, he'd give me his transcript. And I'd say, hey, I did this. And we would just be talking. And then the pandemic hit about almost like 6.5 years ago. And so we were doing this and we said, well, why don't we just put it online, and see if anybody else, can benefit from it. And if great, if not, okay. And if so, then, we help some people along the way. And this is kind of what it has turned into. So, which is really special. The second reason why this is particularly special is, to me, when this episode was launched, somebody close to me said, well, Marianne, it's you and Mike again. I mean, I'm sure you could just probably do this in your sleep. Just, run it back. And I was kind of offended by it. And I told Mike that I was kind of offended by it, because the entire purpose of this platform to me is substantive mastery through intentional thought. And the concept of that is that you're never just running it back. You're constantly growing, you're constantly developing and building on it. And, Mike and I have done this particular, I should say, on depositions, I don't know, 30, 40, 50 times for the blueprints, for voluntary bar organizations, for judges, for law schools. And every single time it's different, because every single time we have taken depositions since then. So to that end, the goal here is that, we've gone through the outline, we've tried to consistently develop it and outline it. And how we're going to run through this is we're going to talk about depositions in general, sort of the basics and things that I think some of us take for granted when we're talking about, how we're approaching a deposition. And then we're going to go through sort of a four-step process in terms of how we even, I mean, Mike, what are you, 14 years in? I think I'm almost 16 at this point. Even 14, 16 years in, we try not to cut the corners. I think I'm probably more obsessive now than I was when I was first taking depositions for the first time when I first came over in civil practice. So we're going to talk about sort of how we prepare in terms of strategy, organization, outlining, the timeline, right? I think some people don't think about how early do I need to start, or do I start 2 days before and just ask a lot of questions and then get there and say what happened next? Probably not the best approach. We're going to go through and actually show the outlines that we use, like as examples. Where again, that's not going to be, it's an art, not a science. We're going to talk through the execution of a deposition. And one of the things that we try and pride ourselves on, and we always have tried to pride ourselves on, is showing actual examples. And they're not always examples of us doing things right. Sometimes they're examples of us screwing up and what not to do. And then finally, we're going to talk about sort of the aftermath of what we do immediately after a deposition. So with that, Mike, I'm gonna pass it over to you, my man.
Sure.
You want to start us off on sort of the basics and how you approach?
Absolutely. And thanks for inviting me back. Good to be here with you again.
Well,
Uh,
wait, Mike. Selfish plug, man. I didn't introduce you. Tell us what you do and then go into it.
sure. So my practice is exclusively on the plaintiff side. Nearly all of my cases involve torts, medical malpractice, defective products, construction accidents, things of that nature. And I think it's important to hear from different practice areas. I like hearing what Marianne has to say, even though my cases have nothing to do with what her cases have to do with. But I always think that there's something you can take away and sort of adapt it to your practice and put it in play. Um, but I think you'll see there's certain things that Marianne and I agree on, certain things maybe we don't, and just part of that's probably different ways to do it. There's no one right way, and part of it's probably because we've got different practice areas, and so different things are going to work. I think it's important to sort of take one step back and look at the rules. So you've got Rule 1.330. And why that's important is because I think there's some practical logistical implication to the deposition. So if you're taking the deposition of a party, for example, that deposition can be used for any purpose. And I think that is why, at least in my cases, the deposition of, for example, a defendant doctor or an engineer that was involved in the design of a product is so critical because we're likely going to be able just to plug and play that at trial if we wanted to. And we may decide that certain clips should be played or certain clips should be used for impeachment. But that's obviously very important. And that's why I videotape just about every deposition. Likewise, the deposition of a skilled witness. So, in a lot of my cases, a treating physician, for example, can also be used for any purpose that's irrespective of whether they're 100 miles away or not. Um, then I think you need to look at that other aspect of the rule that deals with deponents that are out of state or over 100 miles away, because that's another aspect where you're going to be able to use that deposition. And so I can remember, a particular products case I had where there was a non-party but very important witness out in Colorado, and there was no way we were going to ever get them to come to trial. They wanted nothing to do with our case. They really didn't have a dog in the fight, but their testimony was going to be very important. And so when I flew out to Colorado to take that deposition, if I treated it like this is going to be the examination that the jury hears, and so obviously you kind of have to um, hone your questioning accordingly and make sure that there's no going back, there's no second chance. That's it. That's what you're getting. And so prepare accordingly. My preference of videotaping the witness, it's really because I don't see any downside. Obviously, there's a little bit of an increased cost, but I hate the idea of only being relegated to a transcript. Number one, if you're going to use it at trial, it's really boring to read it. I've actually played that role before, being the quote witness, reading that transcript, and I felt like it must have been very boring listening to me try to play the role of some other person who'd been deposed. And number two, there's a lot that you cannot get from the transcript. The way someone says something, the lengthy pause that they take when they're struggling to answer your question. All of that you really can only get by seeing that video. So from my perspective, that's how I go about it. But I think it's kind of a boring and maybe silly thing that we take for granted a lot of times, but you should always be cognizant of the role of the person that you're deposing, how that fits into the rule, and how you're going to be able to use that transcript going forward. I think, Marianne, you were going to talk about corporate reps.
Yeah, I'm gonna get on my soapbox a little bit on this because I know, Mike, I don't know. Do you take a lot of corporate rep depots? I think we've talked about this a little bit.
We do. Probably not as mission critical in your cases, but there are a number of cases where we'll have corporate rep depots on very specific designations, obviously.
Yeah, so I think the words you just said was mission critical. Like I cannot, first of all, I cannot say enough about videotaping. I mean, even when you don't think it's important, videotape it, pay the extra money. Um, as it relates to corporate representatives, like that is the holy grail for at least my practice. And I cannot tell you how many times, which if it's more than one, it's too many, but how many times I have defeated a motion for summary judgment because the opposition noticed it improperly, did not execute it properly. When I say execute it, meaning the rule when you actually get to the deposition, and therefore they couldn't bind my client. Now, again, it's still probative at trial, and they used it at trial, but they missed out on. Again, I don't think that they would have been successful in the motion for summary judgment, but who knows? They didn't even get the chance because the judge found that they didn't bind my client. And so I wanted to talk very briefly about it sounds stupid, but the amount of times this mistake is made, and then I'm going to show you an opinion that literally outlines how many times members of the Florida bar do this, which is if you look at the specific rule, right? It requires you to state the topics with reasonable particularity. And you're like, yeah, okay. The amount of times that I have a notice of corporate rep depot that says, going to take the deposition of the person with the most knowledge and about the allegations in the complaint. And like that happens a lot. And so, I mean, I don't object to it because they're going to take someone and it's not going to bind my client. Yeah, I mean, yes, there's things down the road or whatnot, and they don't even realize it. And so there's a few things that I want to go through. One is you need to state when it says state with reasonable particularity, I'm not saying get granular, but you can't just say allegations in the complaint, allegations in the answer. Yes, you can have that as a catch-all, but you need to actually identify so that then it puts the onus and the burden on the company to find the person who is going to testify on those issues. Now, again, it's probably not going to be, nor does it have to be, the person with the most knowledge. They are allowed, they being the company, are allowed to get someone and prep them. Chances are it's not the person with the most knowledge. When I'm on the other side, I'm not doing that. I'm preparing someone and it's me. So now what does this look like when you get to the deposition? When I get to the deposition, and let's now switch hats, when I'm taking the corporate representative deposition, one, God willing, we've noticed it properly, right? I am handing this as here's exhibit one. Do you recognize it? Yes. Okay. What is it? Well, I saw it. It's the notice of deposition. When did you first see it? Oh, well, a couple days ago. Did you meet with anyone to prepare for it? Yes. And if they're smart, they have the lawyer there, therefore you can't talk about what they talked about. If they just met with the CEO, you can ask what they did. And then if you look at the rule, it is the company is required to designate one or more, right? Because there's different topics to testify and bind the company. Now, the individual has to consent to that. So what I do is take that extra step and I say, and do we agree that you are here to testify on behalf of the company on topics 1 through 4, right? Then I go into my questioning. So it's clean and it's clear that they are binding the company. Now, little fun party trick, right? When I'm on the other side, I say, and do you feel that you are the person in the company with the most knowledge? And then sometimes they say no. And I say, well, then who is? And they say Sally. And they're like, cool, I'm gonna write down, I'm gonna go talk to Sally later on. And then when you depose Sally, she's not gonna bind the company, but it's gonna be probative, and I could potentially use it to contradict each other. So point being is I'm gonna put this up on the screen really quickly just to, because it's now become it's this has happened 3 times to me. Thankfully not against me. Um, Okay. So, and we don't, I won't go with that. I can send the whole thing to everyone who attended so that you can look at this, but I'm just going to read this portion because I think this is what's where the point is. Utilize properly Rule 1.310 B6 streamlines the discovery process and gives the corporation being deposed more control by permitting it to select and prepare a witness. In exchange for that control, the entity is required to have the right person present at the deposition. This, of course, benefits the requesting party as it prevents the corporation from frustrating the opposing party's discovery by simply playing ping pong with him. Okay, now this is the part that I want to get across to. I'm going to go through this. The deposition notice makes no reference to the rule at all, nor does it request that Carriage Hills designate one or more witnesses to testify on its behalf about matters or known or reasonably available. It instead recites that JBH will take the deposition of the corporate representative Carriage Hill Condo with the most knowledge of the allegations of the complaint. Though many members of the bar send such notices, not only does the rule not provide for this type of discovery demand, but the request is also fundamentally inconsistent with the purpose and the dynamics of the rule. And in my opinion, or in my experience, I should say, the court is very, very happy to find that it does not bind. Now, again, you can use it, but it does not bind. So along with that, Mike, anything else, or should I keep rolling?
The only other thing I think we've talked about this is the inability you have of getting the corporate rep to trial and why that brings the deposition to have an added importance. This actually came up in the Rules Committee, the Civil Procedure Rules Committee for the Florida Bar, that there is no mechanism to subpoena a corporate representative at trial. And so I think that it's something you should just know. And therefore, when you go to depose a corporate representative, that's another witness that you'll want to treat that deposition like it's the trial because you may not get another shot.
And I just think this is a perfect example of it's a completely, I don't want to say reasonable mistake, but like you can see how it happens. So really, our goal here is just to make sure that maybe don't make a mistake that you probably know you just like are moving too fast, or that we've made. Whatever the case may be, whatever we can do to shorten the learning curve, or even just kind of things that you haven't thought through. Because being on the other side of this is not only really, really substantively problematic, but very embarrassing. So with that, let's talk a little bit about Mike. I'll start us off on preparation and sort of strategy. I will short circuit and summarize my preparation and strategy, which is I am incredibly aggressive with the subject matter and I am incredibly professional with the people. So I think that sometimes there's this idea that you have to be one or the other. And I think finding that balance is where I feel most comfortable. And along those lines, the way I approach it is when a case comes in, I have already, and my team doesn't ever even see this, but in order for me to direct my team properly, I either, if I have the time, I will not fully write out, but probably more than an outline, a motion for summary judgment based on what I know of the facts. Because I cannot possibly properly do initial disclosures. I can't properly get the discovery I need to do a deposition, and I definitely can't do a proper outline for a deposition if I don't know where I need to go and where I want to go. So I know that seems a little crazy to some people, but that is definitely back from more of a trial mindset, which is kind of in the sense that you don't know how you need to close to a jury if you don't know what pieces you need to tell the jury and need to get in through the witnesses. Same concept. So, with respect to how I am aggressive with my positions, the rule 1.280F was amended recently. I think it was in 2025, if I'm not correct, if I'm not mistaken. It's June of 2025, where they changed this concept of you couldn't start discovery until the initial disclosures were satisfied, and it was changed to served. So a lot of times I've already outlined what I need to do to be successful and take a telescope and look down the road and sort of come backwards. And when I'm serving the initial disclosures, I am also generally serving discovery. And then I am setting the deposition within 45 days. And that is how I am moving, and I am setting the tone quickly. So as it relates to sort of tempo, that's kind of how I operate. When I'm taking a deposition, I am usually operating from about 3 to 4 weeks out of starting the deposition outline. And what I mean by that is I am creating the skeleton of the outline and I am working on it slowly, little by little, with all my other cases going on, because the concept is I want it to the client usually about 2 weeks out, because I want them to have all of their comments and us to discuss everything. Because by the time I'm a week out or a few days out, then I just want to be able to be focused on what's going on. Now, again, some people say, well, how do you do this with all of these cases? Once you get into a rhythm and a system, it's just part of your how you operate. And for those who are listening that are associates, that are like, I have no idea how I'm going to manage that. I have to draw this. I'm generally getting ready 48 hours, 24 hours before. I would challenge and say, perhaps take a step back and suspend disbelief for a second if you changed the way you approached. And I know again, I've been in that position where you're working with certain partners that don't operate in a certain way. However, when you take ownership of a deposition, or even if you're looking to for the opportunity to take a deposition, my suggestion is to start out in advance. I always say this, call the partner's assistant and get on their calendar 2 weeks out if possible. Get all of their comments out. Get all of the client's comments out. Because when it gets to the day of the deposition, you don't want people just passing you notes every 2 seconds. It's really distracting and it's really annoying. But I guarantee you that's going to happen less and less. And I had to find out the hard way. I mean, this is how I developed the system. Is I don't want a note passed to me every 2 seconds. One, it's distracting to me, and two, it undermines my authority. So I always say, listen, hand me anything that you want. I mean, if it's urgent, of course, fine. But I'll take a break every hour and you can give that to me. So that's in terms of why I start that far out. And it's not that that's my only case or that's my sole focus. It's just it's paced out that way so that I'm not doing everything at all at once. And to me, I always say that it allows me to absorb it in my soul by the time I've stepped into the room for the deposition. And therefore, my outline is just something that it's not a Bible. It's just a guide that I can look at on breaks. But I'm so in flow with the conversation that we're having and my follow-ups. So the last thing I want to do in terms of kind of talking about in terms of how I organize the I guess making of the outline is I first go with the law, the facts, and then I figure out how I'm going to place those questions based on what I need to get. And what I mean by that is there are ways to place questions before, and it's not I never try and do like an aha got you moment, right? I never try and say, oh, let me see if I can catch this person, or if I can catch them if I can catch them, like, and take advantage of them or trick them. I just know that generally, if someone is trying to protect their rear end, right? If you're able to ask a question that seems innocuous and they're just going to tell the truth, as opposed to try and figure out 17 ways to get out of the conversation and not give you clean answers, then ask it in that way. So I thought this might make a little more sense if I showed an example. I call this the order of facts. Um, Hold on one sec. Okay, so it's a pretty simple example. You don't need to know much about the case. Basically, the case was a trade secret non-compete where employee goes to a major competitor, which that in and of itself I knew was going to be a big problem if I had confronted her with all of the indiscretions that we had first. So at first just got out obvious questions and answers where, I mean, if you answer no to that and you're videotaped, it's going to look crazy. So anybody with any level of self-respect is not going to do that. So you have this part. I say, okay, and biggest competitor in the digital marketing space. Is that correct? I don't, oh, hold on one second. Oh, she says, I don't know. Is that correct? I don't know. You don't know? And then I say, you don't, are you saying that they're a competitor? They're a competitor. So my point being here is all I am doing, you already see that she is trying to um, get out from underneath the fact that they're a competitor. And this is before the fact that I'm going to go through, which I have a transcript for that. That is before we're ever going to get to the fact that she did all of these things that she's going to have to admit to. So if I ask her all of those things and then I go to and they're a competitor, she's not going to answer that, and she's not going to answer it straightforward. So that's just like an example of trying to figure out and how to place the facts. Um, Mike, I thought it might make sense. I know you have a sort of concept of these, I don't know, undisputed facts, and I'm just interested in your position and your thoughts.
Sure. I do want to go one step back to what you were talking about, about preparation, and I thought it was a lot of really good insight, particularly for younger lawyers, of how to go about doing that with your colleagues and partners and so on. But I think that before any deposition, I look at what I need or hope to get from that particular witness. And I'm doing that in the context of what are the undisputed facts of the case as I see it. And I know I've had a lot of conversations with Marianne about this. The undisputed facts, which will change throughout the case and more depositions and as you barrel towards trial, but it's basically, it could be a short list. It could be 5 facts. It could be 10 facts. But these are the facts that I believe will be undisputed by the close of discovery by the end of this trial, that if I'm successful in demonstrating that, I win. And so when you create that list, each witness that you're going to depose fits in somewhere. Maybe that witness is going to help you get towards a couple of them. Maybe that witness can speak to all of them. Maybe that witness is going to make your life a lot harder to prove a couple of those points on your list of undisputed facts. But this whole concept comes from trying to narrow the, a lot of times lawyers overthink, they talk too much. And I think this is about boiling it down to trial, right? Something that Marianne said at the beginning about treating the depositions more like trial and how that could lead to successful, outcome. And I think that that is where this comes from, is that if you boil it down and make those points, it's how you're going to get there. And I think it really focuses you for each deposition. And so then I'm thinking in advance of each deposition, I'm writing it out. What's the goal here? What do I really need to accomplish from this witness? And then from there, I'm moving to what are the topics? What are the topics that I'm going to cover with the witness? And the reason why this helps me with outlining is because when I'm sitting down and preparing, I've got a million different questions coming to mind. And this question, has to do with this, and this question has to do with that. And how do you stay organized? And so really, I try to start with what the broad topics are. So for example, let's think about it in the context of a medical malpractice case. I'm always going to ask the witness about their background, right? Where did you go to residency? What's your practice like? How many times a year are you performing this type of procedure? So on and so forth. So I always know that general background is one of my topics. Then I'm going to have in every one of these depositions a topic that's very specific to my client. What do you remember about them? Independent of your review of the records before this deposition, what do you actually remember about Ms. Curtis? Have you made any notes? What did you do to prepare for the deposition? All of these things are going to be topics. And then within that, I'm sketching out the different questions I might want to ask or subtopics and so on and so forth. And then, of course, you have very case-specific topics, the interpretation of particular labs or radiographic images or whatever. And then hand in hand with the outline, it's the key documents. And I know Marianne did a nice kind of discussion about the timeline, right? With initial disclosures and discovery and how many days out. Well, then it's about going back through every record you've obtained and every discovery answer you've got. And not all of that's going to be pertinent to this deposition or that deposition, but I'm kind of creating like the hot docs. And so, if I'm doing an in-person deposition, I've got my depo binder that I'm going to take to every single depo in the case. And it's an indexed thing of, here's the ER note, here's the radiology report, here's the this, here's the that. And I'm going to make that play with the outline so that in my outline, it's like, okay, tab 3, this is where that's going on. And that's how I do it. And I don't think there's only one way to do this, but I'll also say that over time, with more years of practice and more depositions, that process has evolved. A lot of questions that I used to maybe like sketch out more, I'm not doing it because it's more muscle memory. But I still am doing an outline for every single deposition. It just might not be as detailed as it once was. The other thing is on those documents that I'm pulling and using, a lot of times I've got notes in the margin that those are sort of the foundation of the questions I'm going to ask. So I wouldn't say that I've not stepped away from that process that we've been talking about for years. I'm just saying that it's evolving and it's changing. And I think that that's normal, natural. And I think everyone should be looking at how to better themselves and how does the process evolve as you've got, more experience. But it's still important because there's some stuff that you don't want to forget, that you want to word in a very specific way. And that's why I do it. And ultimately, the outline cannot be a crutch. It's a tool to prepare, to stay organized, and ensure that you hit everything that you want.
So I think you nailed everything. I think to follow up, and I'll show an example of an outline that I have used and sort of my system. I agree with Mike that your processes and systems should change, and they have for me over, I guess what, now we're going on 8 years in civil. It's the same way my trial work changed. With that said, I think you have sort of a few things, right? And let me see if I can share my screen so you can kind of, it's an example. Let's see. Okay. It's an example, and I think it's a little bit like law school where the effort is the benefit. I find that for me, just start right. I mean, just to put the style of the case, start going. And then I deposition details. And it's so hard sometimes to get going 4 weeks out because you're like, oh my gosh, I'll deal with this a week out. I'll deal with this. Like I'm fine. I've done this a zillion times. But it's this process that's very intentional. What are my goals? Literally writing them out. And by the time, so I write out all my goals, and these are all the things that I'm going. And then I have all my exhibits that I've done at the end once I go through the questions. I go through the questions. And for me, I generally will not write out, I will distill this down to the point where I generally have bullet points and one word. And by the time it's time to go, it's go time. And again, this is just my process. And I think generally the outline is your safe space, right? That you, oh, someone's calling. They want to join our, okay. So it should be something that when you're done, it gives you the confidence to know, which gets to sort of my next point, which is every time that you step into, to me, the lines of litigation, you're sizing each other up, not in sort of an aggressive or inappropriate way, but you're sizing up, and the other side, and I can pull, and by the way, I can send this to anybody that wants, but that's the general concept. And then I will write down specific things, anything that's bold and underlined are things that I really need to make sure, like Mike says, you say exactly how you need it said for the record or for case law. But to me, if you take a step back and you say, what are we doing? What is litigation all about? And to me, litigation is every time around you both have to, the attorney and the opposition is doing a calculus in their head as to are their facts good enough and can they go up against the opposition? And I want them to know at every turn that your facts better be so good because I'm not making a mistake and I'm going to bring the aggression again, not in like a physical way, but I'm going to bring the game to you. So I'm not going to lose this. You better win this. And when you do that and you're constantly a step ahead and you're constantly prepared in the sense that you are directing the actions by doing things like this of what's your system? How are you preparing your outline? And then you get in there and you're controlling the room. There is a trickle down effect that has to the results of your case. So, Mike, I don't know if you have any thoughts. And by the way, if you have any questions about outlines, if you have any questions about what we're saying, put it in the chat. And we're happy to go off script here. But Mike, do you have any thoughts on outlining before we go into like transcripts and situations?
No, I think I've touched on that as much as I can say. I don't know how people do it without it. It's too important to me for the preparation aspect, if nothing else. I mean, I can understand if you feel so comfortable that you don't need it to refer to during a deposition, but I just think it's so critical in the preparation of it and staying organized to make sure. I don't know. I think my biggest fear is that I'm going to leave the deposition and think, oh, I should have asked that. And that happens. But
Mike, it's so funny because I literally had this conversation with a gentleman who was my senior. And he said to me, he said, it just feels like it gets in the way of my flow of my creativity. And I was like, okay, to me, that's like code for I don't really want to prepare. Um, but again, I'm not, I'm
I
not
look
talking
at it
about
though like
anybody.
you could never look at it, but a lot of times I like on a you take a break and then you look at it and you're like, okay, I did that, I did that, I did that. I'm not going to do any of this based on some other answers I got. And oh yeah, I forgot to ask that. I'm really glad I wrote this down in advance so that I could remember to go back in there and ask.
100%. And I do think, though, that there's some component of it's similar to why people don't moot an argument enough or prepare a speech enough. It's because it feels awkward and it's uncomfortable until it's not, right? So the amount of times that I go through this and it's the discipline to get through the first round of an outline is like nails on a chalkboard sometimes for me, even at this point in my career. And sometimes I just want to be like, all right, I got it. Like I can
Yeah,
just do this. So um with that, Mike, I think, let's go through a few of our situations that we've dealt with or that we've got
I
questions
would
about in the
I
past.
would love to. Do
All right.
you want me
I
to
guess
go first?
why don't you go first and then I'll go through the difficult I'll go through the difficult witness and
Okay,
go from there.
sure. So I think that one of the things that I have found to be effective in some of our cases is sometimes to walk through with a witness their experience, their training, let them build themselves up as to why they're so great at what they do and seek their agreement to certain principles. And I wouldn't necessarily ask it as, well, you would agree that X. A lot of people do that. And I've done it before. I'm not saying I never do. But one of the reasons I don't always do it is because something, if you're asking an adverse witness, you would agree X, I think they're going to be immediately skeptical and on guard of what you're saying because it's coming from you. And they don't want to agree with anything you have to say because you're you and they're them. But I think if you can get agreement to different principles about, what somebody does or is supposed to be doing or whatever, and then oftentimes you can use that to the facts of your case to demonstrate why, your way is the right way and you're going to win. So I'll show, two quick examples. One of them comes from a a case involving medical malpractice of a radiologist. And not to get too into the weeds or bore people with the facts, but to understand what was going on here, there was a CT done of someone's abdomen and pelvis, but there was this very significant abnormality in the spine that went overlooked and never reported on. And when I deposed the defendant doctor, they basically took this very strong approach that you would never look at the spine on a CT of the abdomen and pelvis. You just wouldn't even do that. And ultimately, they get an expert who says, well, it's too difficult to see on this image, but in hindsight, it's definitely there, but it's not negligent to have not reported it because it's very difficult to see. And so I'm going to share my screen. Hopefully you can see it, but never see it that well.
Yeah.
What I said here to the expert here is the standard of care for a radiologist is that when he or she is interpreting an image, a CT of the abdomen and pelvis, they should absolutely be looking at the lumbar spine as well. Yes. If there's an abnormality on the lumbar spine, they should report it. Yes. If they don't do that, they're below the standard of care. Yes. And then I go back to what the defendant doctor said. So we'll call it Curtis, Dr. Curtis testified that he didn't look at the lumbar spine. That's wrong. It's below the standard of care. Yes. And what I did here is sort of just boil it down into just like normal people talk. Basically, your opinion is you're lucky because you did the wrong thing, but I don't think it matters because I didn't see it until retrospectively. Answer, yes. And I think if you stop for a minute, like why I found that to be pretty powerful is because it sounds so stupid. But that's their case. Their case is, yeah, the person that I've been hired to defend and say met the standard of care, they definitely did the wrong thing by not looking at the lumbar spine at all. But I don't think they were negligent because I couldn't see it until retrospectively, now that I've got more information, now I can see it. And so when you put it that way, like, yeah, your whole opinion is the guy's wrong, but he got lucky. I don't think anybody likes that, but that's their opinion. And that really, I can tell you that it turned out that bit of testimony turned out to be very important and kind of a turning point in the case. And then, one other example I'll give that's a little bit more involved, but it involved a patient who post-operatively, unfortunately, developed some complications and passed away. And one of the issues was that they had too much fluid on board. And so when I deposed a nurse, and you can see I kind of saved this file as set the stage. And it was, you want to make sure a patient does not have too little fluid, and you want to make sure that the patient doesn't become fluid overloaded. And you can see I'm getting all like, yes, correct. If a patient's fluid overloaded, it can be dangerous. It could damage their cardiovascular system. You would want to notify the physician. That's required by the standard of care. And later in the deposition, you can see like that's page 94, 95. But later in the deposition, we come back to the very specifics of this patient. And now I've directed them to, okay, at the bottom of this page, this tells you the patient's fluid balance. Yes. So now we're actually going through the actual record of my client. And then ultimately, the nurse agrees, my client had a significant amount of fluid on board. It's a significant imbalance. And this goes to what I was saying about building them up. You've been in healthcare for 30 years. You've been at this hospital for almost 16. You've been on the med surg floor for a long time. You understand why it's very important to measure the patient's intake and output. And that's something that you want to make the physician aware of. And so ultimately, the physician was never made aware of that. But now the witness is married to this because they're sitting there realizing, well, gee, like I've been doing this for 30 years and I do know that that's a very important thing. And I can't sit here and lie and say, no, it's no big deal. You can just let that go. So that's sort of a concept that we've used in a lot of cases of trying to sort of set the stage with principles that shouldn't be controversial, let them agree to those things, You don't have to necessarily word it that way. And then later on, use that presented to the facts to demonstrate your case. And I think one of two things happens. Either one, they're going to realize, like you see there, like, oh yeah, like I goofed up, and that's great for you. And number two is they're going to try to dance around it and, tell you, no, the sky isn't blue. And that's okay too, because it's not credible. It's just not believable. And it took me a long time to get to the point where, I'd leave depositions frustrated, like I can't believe that I couldn't get Marianne to say X. And then I realized, like, well, of course she's not going to say X because she's on the other side. She doesn't want me to win. She wants to win. And that's okay because if they're saying something that you don't believe and that you don't think anybody else believes, um, then you're doing a good job. And a lot of times I ask the court reporters, when no one's around, you're packing up. What did you think?
What do you
Yeah,
think?
buy it because that's a juror. But anyway, that's what I've got.
Yeah, I listen, I think the one thing that really jumps out at me at your transcripts too is how clean they are. And we've talked about this a lot. We agree on how I always start a deposition. Okay, not always, but most of the time. My style is very direct. And generally, it's good for both sides to figure out what we agree on and what is not in like what is not in dispute, and then we can later on like fight about things. So a lot of times I'll say, listen, I understand we're on opposite sides of the V. You may not like me, you haven't even met me, and you automatically distrust me. I want to first start off with the things that I think we agree on. Because a lot of the times they agree on things that are innocuous that help you, that they should agree on if they're telling the truth. And I don't do, you would agree with me with X because I tried that and that is not the way to go. Because again, you're not tricking them, but they automatically think that. So I think that is it's just you've got to figure out your style. But I like to clear the deck before I get to, it's clear that we're going to probably tussle a bit. Um, so anyways, I think that's spot on, Mike. I'm
And
gonna
I think
touch.
one
Yeah,
other
go ahead.
thing before you take it
No, no,
away, I think it's important to the same thing I was saying about trying not to be frustrated when they say stuff you don't like. You know, um, I can remember once talking to a younger lawyer about, they didn't want to ask something because they were like almost afraid of what the witness would say. And I was like, well, no, like you have to know what they're going to say. You can't be unprepared. And so one of the goals generally should be that you're going to learn everything that that witness thinks about your case, good, bad, or otherwise. So that I wanted to make
no.
that.
Yeah, it's interesting, and then we're going to go into an area that Mike and I don't disagree on, but like I think there's different circumstances based on our practice as to whether you want to ask the ultimate question, you want to literally have everything on the table. But in my entire career, jury trials, depositions, there's been about maybe two or three times that I've had that Perry Mason moment. You're generally not getting it. So like understand, that's why I think it's important to understand what your goals are. And your goals is not to just like have this gotcha moment, because that's really not what we're doing. So I'm going to cover two things over the last 10 minutes. One is difficult witness. And I think that this is particularly hard sometimes I hear from women to deal with and young people and or young women. Not exclusively, obviously, but you have a very difficult witness that is just and a lot of times it's experts too, right? Um, this is what happened in an example I'm going to show you, and I cannot tell you enough. One, make sure you understand the hill that you're dying on, and it's worth dying on. Only die on hills that are worth dying on. Otherwise, put your ego away and keep it moving. It's not worth it. You got to keep because depositions are about pacing and tempo. So don't lose it by getting into the weeds just because you don't want to like relinquish something. This one in particular was important. It was something stupid that we did not need to fight about. But here we are. We're fighting about a date that was very important. And it was not in dispute, but we just could not get this witness to just say what the date was. So I'm going to just the highlighted because if not, you're all going to be bored out of your mind. I say it looks as though this document was signed on January 23rd, 2006. Is that right? Document speaks for itself, ma'am. And I mean, that is not, unfortunately, that's not an answer that I can have. Now, don't get frustrated. As you can see, we now go on for another page and a half. And when you said I don't see another date, is a different date other than January 23rd, 2006. I even say I'm not trying to be difficult. I'm just trying to make sure we're on the same page, like literally on the same page. We're looking at a document. Um, and then by the end of it, he then finally gives me this, like, I mean, it's just you can imagine what the temperature of the room was. January 23rd, 23 day of January, comma 2006. I mean, just like these are difficult witnesses that you know you're going to come across. Don't get frustrated. It's just keep moving. And then I want to show you another example because someone reached out to me about just an example of asking the ultimate question. And I also thought this was a good example. Mike has a saying that I could not agree more with you. You've got to be a good listener. And the only way you can be a good listener in a deposition is if you're prepared and you're not freaked out looking at an outline that you frantically put together or like put in chat GBT and or Claude or whatever else, AI platform that we're using, and you're just sort of like trying to like triage. The only way that you can really be a good listener is if everything that you need for this deposition is like already in your soul. So I'm going to show one example in honor of you, Mike. All right. Again, you don't need to know the facts of this case. Basically, I say, did you give the assignment? You said you made copies. Who else did you give the assignment to? This particular witness, I could not get this witness to, and again, I don't know that they were trying to be squirrely. They just couldn't focus and give clear answers. So then the witness says, I did not physically give that assignment to someone else, anyone else. So I say, okay, even though she just, so now I have a clear answer. And but then she says, I did not physically give. So me being, trying to be a good listener, well, I mean, did you email it? Like, I don't know. Is there other way to physically, I did not physically give it? Like, are you giving me a qualifier? Or are you just speaking like a robot? I'm not sure. So I say, and you just to clarify, because you just said I did not physically give that assignment to anyone else, did you send? What does that mean when you say I did not physically give it? You didn't give it to anybody? I spoke of it. I didn't give it. Okay, so she's talking about physically giving it. So why did I not just say give it? But okay, now we're clear on that. And then I say, okay, so let me be clear. During the divorce case, you did not give the assignment to anyone else and you're excluding this was, something specific. Is that correct? Is that a correct statement? That is correct. And when you said you spoke of it to other people during the divorce case, who did you speak of it? If you're saying during the divorce case, I did not. Now, the reason why I said I was going to ask the next question. The next logical question was to include, it was an issue that needed to be addressed about my client. To clarify, now we're saying you did not give it to my client. You did not speak of it to my client. But she had already said I didn't give it to anyone. Now, Mike and I sometimes talk about whether we are going to ask that ultimate question. And I would say 9 times out of 10, I'm a bull in a china shop. So I'm asking that ultimate question because I want crystal clear. And this time I didn't. And I knew this was going to trial. So I knew that at trial, if all of a sudden we backpedaled and somehow she was going to say, well, no, my client was not included in anyone. When you said anyone, I was going to have a moment with the jury. So you got to know the circumstances and the situations that you're working with. Mike, we have a few moments. I thought I want to kick it to you just if you have a few follow-ups. And to be honest, I don't take a ton of depositions over Zoom anymore. Um, but that could probably be its own CLE in and of itself. But I don't know, Mike, you have any questions before we talk about sort of the aftermath quickly?
I don't have questions, but I do want to say this because I know you made the kind of joke about ChatGPT, Claude, etc. I think that it's not a substitute, just like the
No.
outline can't be the crutch. But I got to tell you, like I've been using the different AI tools, and it's very useful. It's um, it's very useful as a second set of eyes, coming up with different ideas, and I've recently used it extensively to prepare for one particular deposition where it was sort of like as I was going through the file, the different hot documents and making my outline, I was feeding the information and the stuff that was coming out, a lot of it was very useful. Um, for whatever that's worth, I think it's a thing that should be fooled around with, but definitely not like, hey, make the outline. And honestly, like the analogy I would draw to that is back in law school, asking for someone to give you an outline that you had no
Right,
input on making. Just like, hey, can I get your
right.
outline for that torts class? Like, I mean, is there a value to that? Limited, but something. And it's the same thing. Like, you've got to do the work, but I think it's another tool to assist with doing the work.
Yeah, no, I completely agree. And I think it's actually even funnier. I think it's the analysis of someone giving you an outline in an open book test. So it's even more frustrating because you have like limited time and you're like trying to look through something. But I agree. I think we use it as a tool, but it's not going to put the information in your soul
Yeah.
the way you're going to.
The only
Um,
other thing I took a note on this was that because neither of us, I don't think, mentioned this with preparation. Like I know you mentioned talking to the other lawyers working on the case and things like that, but conferencing with your experts, that's huge because, my God, they're gonna want to know certain things and you're the mouthpiece to go get it.
yep.
And their help is invaluable in understanding the material before you go and question witnesses on that. So I love making sure that I get conferences with the experts before the depositions with plenty of time to like digest what I'm learning and so on and so forth.
And I think that kind of segues pretty nicely into sort of the last comment, which we had a little bit more time, but the aftermath, right? I think while it is fresh in my mind, I will just freehand write some of the top 20, 25 things that came out of the deposition. And then along the lines of the strategy of your case and just who you are as a lawyer. For me, again, it's aggressive with the substance. Um, I'm thinking about, is there a motion to compel here? Is there a phone call to the other side to say, hey, listen, is this an off ramp? Do we need to have a discussion? There are different ways for that. Do we need to get to a mediation? Do I need to file a motion for summary judgment and do it temporally, like quickly, to send messages and to that sort of thing of like be clear in terms of our intention. I think there's just a lot of things to think through as opposed to just don't sit on a deposition when it's done. uh, think about how you can use that then to leverage the next one, which is what discovery do you need? What other depositions should I get to while it's fresh and while it's hot? Um, so with that, Mike, I'm going to give you the last word, but I do want to just thank all of you. If you need or want to talk through anything, any of your depositions coming up, any of your outlines, if you just want to discuss anything regarding this topic or anything else, we're always available. Just reach out. Mike, super grateful for you taking some time out of your day to come back and hang out with us. So Mike, I'll give you the last word in terms of anything you want to leave the folks with.
Thanks for the invite. I do think with so many Zoom depots, a lot of times I'm asking the opposing counsel to hang on the Zoom after. Because like
Oh,
it used to be very easy. You just would like walk out with the opposing counsel and you talk or, last fall we did some expert depots in person around the country and we shared Ubers to the airport. But on Zoom, you're not getting that. So a lot of times I'll just ask like, hey, can you hang on the Zoom for a minute? And then that's an opportunity to talk about like, hey, like I don't think that went well for you. And like where are we headed with this case? And whatever. Um, I'm using that more and more because God, it's so hard to get people to like have a conversation.
yeah. Can't co-sign that enough. So Mike, super grateful for you, man. Thanks for joining us, and we look forward to seeing you all at the next one. Take
Thank you,
care.
Marianne.
Bye, guys.